Bisset v. Wilkinson, 1927. AC 177 is a leading contract law case from New Zealand on the issue of misrepresentation. The case establishes that a mere misstatement of opinion given fairly cannot amount to a misrepresentation. The case was heard in London by the Privy Council, which was then the final appeal court for New Zealand. As such, the decision, although very strongly persuasive on English contract law, is not conclusively binding. Nevertheless, the case has been cited and applied in England and Wales several times. Facts. In New Zealand in May 1919, Mr. Wilkinson entered into a binding contract to sell to Mr. Bisset 2 contiguous blocks of farmland for 13,260 liras. These blocks comprised 2062 and 348 acres, 1.41 square kilometers, respectively. During negotiations, Wilkinson told Bisset that, with a good 6-horse team, his idea was that the farm would carry 2,000 sheep. After 2 years of unsuccessful farming, Bisset concluded that the land could not support 2,000 sheep, and he brought an action for misrepresentation to cancel the contract and get his money back. Advice. The Privy Council advised that the statements about the farmland could not amount to serious representation based on Wilkinson's knowledge. At the time of the deal, both parties understood that Wilkinson had not used the land for sheep farming, and thus any statement as to the farmland's capacity would only be an estimate. Giving the leading judgment, Lord Merivale stated that important considerations were the material facts of the transaction, the knowledge of the respective parties and their relative positions, the words of representation used, and the actual condition of the subject matter spoken of. Single quote. The judge added. In addition, Lord Merivale noted that Bisset had failed to prove that the farm, if properly managed, was incapable of being occupied by 2,000 sheep. Viscount Dunedin, Lord Atkinson, Lord Phillimore and Lord Carson agreed. Significance. The case clarifies that a misstatement of fact may be a misrepresentation, but misstatements of opinion, intentional or are not. By contrast, in situations where one party has specialist knowledge of the subject, so that his opinion is one which is effectively a statement of fact, then the misstatement becomes an actionable misrepresentation, as in Esso Petroleum Co. Limited v. Marden, and in Smith v. Land and House Property Corp. See also Smith v. Land and House Property Corp. Esso Petroleum Co. Limited v. Marden. Misrepresentation in English law. English contract law.